Welcome to EUPrivacyForAll, Session 34 on GDPR, Position of the Data Protection Officer, Article 36. In the frame of negotiations, European Parliament suggested that the DPO should report to an executive management member responsible for the compliance. It was not taken on board as such. However, the proposal to maintain the professional knowledge of the DPO was retained, as well as the one of being bound by secrecy. On its side, EU Council suggested that resources necessary to carry out the tasks of the DPO would be provided. It was retained. It also mentioned that the DPO shall act in an independent manner and that he shall not be penalized by the ControllerProcessor for performing his tasks and directly report to the highest management level, which was laid down. Article 36 makes clear that the controller and processor are the one targeted. The controller and processor shall properly and in a timely manner involve the DPO on all issues which relate to data protection. They shall also support the DPO by providing resources, help him access to personal data and processing operations, and maintain his or her expert knowledge. Data subject may contact the DPO directly on issues related to the processing of data. Additionally, the controller and the processor shall make sure that the DPO will not receive any instructions and will not be dismissed or penalized because of accomplishing his task. He will also directly report to the highest management level. He will be bound by secrecy, and if fulfilling other tasks and duties, will have to make sure that there is no conflict of interest. As noted in the precedent session, the appointment of a DPO is not mandatory. However, when designated, he has the obligation to help implement appropriate measures regarding privacy risks. He also has to be indicated as an information regarding data subject, controller's records of processing activities, notification of personal data breach, prior consultation of a DPA, or in the frame of BCRs. In the directive currently, let's notice that Recital 49 stresses the fact that the data protection official must be in a position to exercise his functions in complete independence. What should accountable data controllers and processors get prepared for? First, involving the DPO on all data protection issues. Second, providing resources and the possibility to access the processing operation whenever needed, as much as maintaining his or her specific knowledge. Ensuring that the DPO will not receive any kind of instruction and will not be dismissed or penalized for performing his tasks. He will also have to directly report to the highest management level. He will be bound by secrecy, and it should be checked by the controller or processor that the DPO or the tasks do not enter into any kind of conflict of interest. Data subjects will have to be informed that they can contact the data protection officer. The contact details of the DPO should be provided accordingly. And concretely, it means that the controller or the processor, being in a position to be consulted on core assessments regarding DPIAs, BCRs, data breaches, prior consultation of DPAs is key. And the DPO will have to help to identify risks related to the processing, to assess those risks, and to determine the best practices to mitigate those risks. What will be interesting now is knowing more about the resources to attribute to the DPO, how to ensure the absence of conflict of interest, and having an EDPB guidance on the independence or the data subject consultation framing.